We're here today on an objection to a child support recommendation. It was filed by Mr. Kerr. So, Mr. Kerr, what would you like to say in support of your objection to the child support recommendation?
Your Honor, due to our current custody arrangement being 50-50 and all of our finances for Madeline, our child, being split 50-50 between both households, I just feel that the child support shouldn't be raised so significantly. I did get a new job back in April 17th, and it raised $3. I know, which isn't a lot, but as of now, her school tuition, is $233 a month on top of child support, and then we split that. That's just my half. We split horse lessons, we split swim, we split taxes every other year. The communication between both households been very civil. We also carry full health coverage for the child as well. I just feel like that's very, very high on top of everything that we already pay for 50-50. I'm not saying I don't want to pay child support. I understand that it's going to happen. I'm just saying that with our custody arrangement and our communication and what we pay for the child and how we split absolutely everything. And if one household can't do something, we contact the other household and they're more than able to, that's just my understanding and what I want to see happen.
The expenses that the two of you split, is that something that was agreed in a court order or just something that the two of you agreed to on your own?
Court order is 50-50. So we agreed to split everything right down the middle. Madeline spends a week at her mom's and then a week at her dad's and then a week at her mom's and a week at her dad's. So we switch every Friday after school.
My question was the expenses. Did you guys agree to that in a court order, or is that's just something the two of you agreed to? As far as not how much time you spend with her, but how you pay the expenses.
How our expenses are paid is something that we agreed on. We just figured that was fair for both households to split everything right down the middle. And then we even split taxes every other year too.
And then as to insurance, you indicate that you carry insurance for the child?
Yeah, through my new place of employment, I carry insurance for the child as well.
All right. And is that the policy that then is used for her insurance at her appointments, or is there a different policy that is used?
I believe that she used to have a policy over with her mother, but we did switch her to mine because my policy was, I believe, a little bit better. So I think she's just on mine now.
Okay. All right. Thank you. Ms. Keller, is there anything that you would like to say regarding Mr. Kerr's statements and objection?
No. She has two insurances though. She has one through Cody and then she has Medicaid as well.
Okay. And what about his indication that the two of you have agreed to split expenses outside of child support? Is that accurate?
Correct. I would like to point out though that when we split and child support was put in place, the Cody was to pay daycare costs instead of paying child support. So it's my understanding that the child support has changed because she's not in daycare anymore. So he was paying the daycare every week plus the extra child support to make up the difference. But now that there is no daycare, that's put back onto the child support. So that's my understanding why the child support went up.
Do you think the two of you have a order that says you're splitting all those expenses that you mentioned, or that's just a agreement between
No. I think that's just something that we just mutually agreed upon.
Okay. And you're not asking this court to deviate from the support recommendation?
No, I am not.
Okay. Front of the court, is there any input from front of the court on this matter?
Just that the ordinary medical amount in the recommendation and in the current order is assigned to the state. Otherwise, there's no information from the front of the court.
All right. So if Mr. Kerr is paying, has his own private insurance, do you see any issue if that particular amount was reduced from the support recommendation?
I do not.
Okay. All right, Mr. Kerr, is there anything additional you'd like to say, sir?
Well, we pay, well, now that daycare is over, we do pay tuition, but other than that, that's all, Your Honor. We've covered everything.
All right, so under the child support calculations, it does not take into effect any other agreements the parties have regarding paying other expenses. So, and it cannot be reduced based on those agreements. So your objection related to that issue would not be granted. However, to the medical, given that you do have insurance available for the child, we would reduce the support, the payment of the ordinary medical, which was to reimburse for a policy that Ms. Everett has for the child. But since Mr. Kerr does have that coverage, we would reduce that $28 expense from the child support recommendation. But I do not find that there is just cause to adjust the other portions of the support recommendation based on the objection. Do you have any questions, Mr. Kerr?
So you're saying that it's going to be $28 less a month?
Correct.
Okay.
Ms. Keller, do you have any questions?
No, I do not.
All right, thank you both for appearing. That does conclude the status of this. You may sign off.
This is a show
Thank
cause hearing for the defendant. This hearing has been adjourned from July 19th and September 13th of this year. Back in July, the defendant appeared and testified that he was employed. He was ordered to pay $300 by July 31st and August 31st. For appear in September, there were no payments made. On September 13th, the defendant testified again that he attained employment, was making $20 an hour, and was ordered to either pay monies out of his first check or set up an income withholding order. To this date, there have been no payments since August 2022. And the defendant called the front of the court office yesterday, provided the employer information, and indicated to make a $200 payment.
What is the, I think I missed it, the regular monthly payment?
It's $229, and the account balance is $6,840.06.
Thank you. Are you working, sir?
Yes, sir, I am.
All right, and how long have you been working?
Since the 3rd of this month.
All right, and prior to that, how long had you, what was your last job?
My last job was the Future Hybrid Home Builders. They hired me, but they never called me in for work. They said they would put me on call. And after a couple of weeks had went by, they said that they didn't need my help. So I started looking for other employment opportunities and found opportunity at Wolverine Insulation. Yeah. I have my first check stub here. I started on the 3rd of October, which was one day before the end of the pay period. So my first check was just for one day, but I get paid again today, and I will be able to make the $230 something payment. And I can also borrow some money from my brother and sister to pay the whole $600 if I have to.
All right, well, you're actually behind almost $7,000, correct?
Correct.
Yes.
What's your plan to get that taken care of?
I've already established an income withholding with my boss, so that way I can just have the payments come right out of my check and they can be on time. And then anything that I make besides that, I'll be making extra payments towards my arrears because of how far behind I am.
All right, so when we were here in July, you indicated you were working. Is that correct?
Yes.
All right, what job did you have at that time?
At that time, I was just doing handyman work under the table, working with my stepdad, trying to find anything I could get. This is actual employment. It's a tax-paying job. This is real employment.
The handyman would work with your dad. How long were you doing that for?
I don't know, on and off for like 2 years.
Okay. And do you live on your own or live with somebody?
I am currently living in the basement of my mother's house and my stepfather's house. I'm trying to find a place of my own, but I have to get caught up on these payments first.
Do you pay them any rent?
I owe them rent, But they're not charging me right now because of the situation that I'm in. But I owe them about $2,000 in rent.
When was the last time you paid them rent?
More than 6 months ago.
You had any other sources of income other than that handyman work and the new job in the last 6 months?
No, sir, I have not.
All right, anything else you'd like to say, sir?
No, sir.
All right, Ms. Miller, do you have any questions or comments that you would like to make?
Yes. The last time we were in court, he said he was working. It was his 4th day of work. He's been at work. And our son is 7 years old. I think it's 7 years of excuses. Nothing's consistent. Nothing is the same. There's no responsibility shown. He's had plenty of opportunities, plenty of chances. This is my first time coming to court. Other times that he's went to court, nothing's happened.
All right, thank you, ma'am. All right, so given the situation in this matter, I am going to recommend a finding of contempt and set the matter before Judge Hunter on December 7th. I do find that Mr. Waney had the capacity to pay out of available resources some portion of the amount due, and I'm satisfied with the exercise of diligence. He could have had the capacity to pay all or some portion, and that he has not acted in good faith. He's not made a good faith effort to pay. As indicated, there has not been a payment for over a year. He has had certainly some income throughout that time, and yet has made no payments. Through his own testimony, he acknowledged he's done some handyman work and has had some employment throughout that time frame, but has not made any payments. So I would recommend that finding of contempt, set that matter on December 7th before Judge Hunter. I would indicate that if Mr. Waney makes a payment of $3,000 prior to that hearing date, then that hearing date would be canceled.
Understood.
Any questions, Mr. All right, Ms. Miller, do you have any questions?
No, Your Honor.
All right, thank you both for appearing. That does
Ms.
conclude
Miller.
my thing. We're here today to address, you may sign
Thank
on
you.
child support in this matter, in particular potentially when the effective date is. Front of the court, do you have any information you wish to provide on this matter?
Yes, Your Honor. On August 8th of 2022, the front of the court mailed out a child support recommendation. There were no objections, and that became the child support order. That order was effective was to be effective at a later date once the parties were no longer residing together. On August 4th of 2023, the front of the court mailed out a recommended order with the effective date of March 1st, 2023, after they obtained information that the parties were no longer residing together. Subsequent to that, the front of the court submitted an ex parte motion to the court to set support at 0 effective that date because the defendant's income was based on 80 hours a week versus 40. And to correct that order, support was zeroed out the effective date of March 1st, 2023. And now the front of the court is asking the court to determine what effective date of the new order should be.
Thank you. So, ma'am, when did the two of you stop residing together?
I want to say it was around February or March because he had moved over to his girlfriend's house. So therefore I was residing still at Trillium Trail at that point in time.
All right, so you resided at Trillium Trail, which was the marital residence, is that correct?
Yes,
And when, are you still living at that residence?
I am not.
When did you move out of that residence?
The end of August, beginning of August.
And during that time frame from March through August, did Mr. Noel reside at the Trillium Trail residence at all?
No, he came back for about a week and then he left again.
Okay, thank you. All right. So, sir, you currently reside at the Trillium Trail address, is that correct?
No, I just sold that property
Okay.
the 25th of last month.
Okay. When is it that the two of you stopped residing together?
I was back and forth. It's hard to say. I never stayed there all the time because for one, I didn't want to live with my ex-wife.
Well, how back and forth was it, sir? Say from March to August, how often do you think?
I'd stay there for a couple weeks off and on.
All right, what does that mean? You would stay at 2 weeks at a time, or you would stay a week and then stay another week?
It wasn't very often, no.
Okay.
I was there,
That start-
I was like, a total of like 2 months after the divorce.
Well, starting when did you, is it accurate that it was kind of February of this year or March of this year when you would spend time somewhere else?
What's the question again?
When was that you started spending time somewhere other than that residence?
Like the end of March, beginning of April.
Okay. And then between that time, you think you were there for maybe a total amount of time of about a month or two, is that correct?
Yeah. And we still split bills the entire time she was there.
You split the household utilities, is that what you're saying?
Yes, sir. And the mortgage.
How about, and the mortgage? When did you stop splitting the mortgage and the bills?
After I sold it, September 1st. Well, I sold it September 25th, but she moved out September 1st. Is when she gave me the keys.
Thank you, sir. Ms. Noel, is there anything additional you'd like to say based on the comments of Mr. Noel?
When he had moved out, it was my dad and I paying bills because my dad and I were still residing there. And then when my dad moved out, I was paying my half of the bills. So yeah, I was still paying bills there, but it was supposed to be condition of the divorce that it was just Chris and I splitting the bills, not Chris, I, and my dad.
All right, so was he paying any of the bills during that time frame of April to September?
I honestly don't know. He'd send me pictures of what the bills were and I would pay what my half was. So other than what anybody else was paying, I really don't know. I just gave him what my half was. I was splitting it to where my half and then my dad's half. So I honestly don't know what Christopher, Noel, and I what was paying because we don't really communicate much.
All right, but you were paying half, is that correct?
I was paying half, yes.
Okay. And during that time frame, none of the utilities ever got shut off?
No, he had threatened to shut them off, but no, they never actually got shut off.
All right, thank you. Is there anything else you'd like to say, ma'am, regarding this issue?
No.
Sir, is there anything else you'd like to say regarding this issue?
Yeah, during that time, her dad wasn't paying his portion for living in the basement, so I had to cover, that portion.
Okay. All right, so obviously the issue in this case is that there was either of you have an attorney?
No, I no longer have one. I had one for the divorce and he resided.
Sir, do you have an attorney?
I've actually been talking to one. Oh, there she is.
All right, so let's go in reverse. I didn't see an appearance for a new counsel, and I didn't see the old counsel present, so I did not know there was an attorney. Counsel, if you could please place your appearance on the record.
Thank you. Christy Van Massenholt on behalf of Christopher Noel. And my office mailed an appearance. I guess I was hoping it would be emailed as well, but I apologize it didn't make it to your desk.
No problem. What would you like to say regarding this matter?
I guess the testimony from my client was essentially what I was going to bring out was the fact that the parties split the bills, even if he wasn't physically in the residence. He was still, let me back up. The idea behind the judgment was that the child support would start after he moved out. Being me, he moved out contributing to the household bills. Because he was still contributing to the household bills, the intent of the judgment was being honored. And so the retroactive date should be September. It's based on the testimony of my client. And if the court needed an evidentiary hearing to provide the proof of that, absolutely understand.
Okay. Do you wish to ask your client or Ms. Noel any questions?
No, the court asked the questions that I would have asked.
All right, thank you. All right, so based on the testimony provided, it is the court's recommendation that the effective date would be September 1st of 2023. Any questions, Ms. Van Massenholt?
No, Your Honor, thank you.
Ms. Noel, any questions?
No.
We have the parties on that matter. Thank you all for appearing. It does conclude the matter, and you may sign off.
Aaron's here. I'm not sure if Christina's on yet or not.
All right, Ms. Brown, can you hear me okay?
Yes, I can.
All right, and we do not apparently have the current custodians, Bernie or Barb Metelsky, present. Okay, Ms. Brown, this matter was referred to the friend of the court following an ex parte motion that was filed by you.
Mhm.
What is the current status of this matter with you and Mr. Metelsky? Are there any agreements?
I did add on what our agreement would like to be as far as the children coming back to live in my home and what kind of parenting time agreement we'd have. I'm not sure if that made it to your desk or not. I believe
All right,
it
so
was.
what is it that, can you just kind of go through what the two of you have agreed to?
Basically that we want to keep our parenting time agreement loose to reflect whatever the boys' activities are, but primarily with me during the week and Aaron's on the weekend. And then rotating the holidays between both of us. And then we did include the grandparents in there because we do feel that the boys do have a very established relationship with them, and we want to facilitate time with the grandparents as well based on the boys' schedules.
All right, so the two of you agreeing to joint legal and joint physical custody?
We wanted to retain the physical custody remain with me and the joint legal custody between the two of us.
Okay, so joint legal and primary physical with you, is that correct?
Correct.
And his parenting time would be on the weekends, is that correct?
Primarily, yes. We've allowed for a lot of flexibility between the two of us based on the boys' activities. We've tried to keep in mind what's best for the boys and to make sure they have the opportunities to do any activities they want to do.
Do you want the language to be as the parties agree or some type of specific language?
No, we can do it as the parties agree. We're willing to work together very well at this point.
And do you know approximately how many overnights you would anticipate for Mr. Metelsky?
With being primarily the weekends, I'm guesstimating about 52 weekends. So what did that be, about 100 overnights roughly?
All right, plus you guys would share holidays, is that correct?
Correct.
And are you going to share holidays based on the court's guideline or just as the two of you agree?
As the two of us agree.
And do you feel this is in the best interest of your children?
We do.
Now, the children have been obviously with the grandparents for quite some time, correct?
Correct.
What type of parenting time or how much time have you seen the children during that time frame?
It's been a little sporadic because of living in Grayling and them being in Vanderbilt and going to Gaylord schools. During the summer, it's more, obviously, and then during the school year, it's a lot more or less. It's about 1 weekend a month during the school year is all we've been able to manage.
Okay. So as to school, what's the plan there?
We've agreed that they would switch to Grayling schools.
Is that switch taking place immediately at a semester break at the end of the year? What's the plan?
We spoke to the boys and Finn requested that we wait till after Halloween because he had a marching band event he really wanted to participate in. So we agreed to November 1st.
Do you know if the grandparents were aware of this court hearing today?
They were.
Do you know if they plan to attend or did they express any comments to you regarding this matter?
They haven't communicated with me. I believe they sent Nicole a text that they agree with our custody agreement and the boys returning to me, and they didn't have any intention of being here today.
And you said you live in Grayling, is that correct?
Correct.
Do you own a home or live with someone or rent?
I live with my partner for about 5 years.
Okay. Do you have adequate housing for the children there?
We do. It's a 2-bedroom house, so they'd have their own bedroom to share there.
Okay. Anything else you'd like to tell me, ma'am?
The only other thing too is we request that the child support be redirected back to me with this. And I think that was everything we had in there.
Thank you.
Thank you.
So, sir, are you in agreement at this time that the two of you would share joint legal custody, that Ms. Brown would have the primary physical custody, and that parenting time would be as the parties agree?
I do.
And it's your understanding that essentially you're going to have most of the weekends, is that correct?
That is correct.
And then the two of you will also share holidays as you agree, is that correct?
That is correct.
And are you in agreement to having the children enrolled in Grayling schools?
I am, yes.
I didn't ask Ms. Brown this, but how about the summer? Do the two of you have any different arrangement for summer, or would it still be weekdays with Ms. Brown and weekends with you?
We talked about doing every other week during the summer.
Okay. Is that correct, Mr. Metelsky?
That is correct.
Okay. And sir, do you think this is in the best interest of the children?
Yes, it is.
And what kind of parenting time have you been able to exercise in the recent past?
In the past, it's been every other weekend, and I've go up to my parents' house about every weekend, up until my parents started doing some, we'll call it shady stuff. But other than that, they'd come up with excuses why kids couldn't come down more than that. So it was every other weekend.
Okay. So based on the stipulation of the parties, I would indicate that the custody and parenting time should be amended to reflect joint legal custody, primary physical with plaintiff. Parenting time is as the parties agree, with the intent that it would be every weekend for dad and then every other week in the summer and share holidays. The parties have also stipulated that the children can attend school in the Grayling public school system. The two of you are able to agree as to how the transportation and exchanges are going to work out, or do you need a set schedule for that?
We can agree to that, I believe.
All right.
We
Do
can.
you agree with that, Mr.? Okay. We'd also issue a new support recommendation based on the change in circumstances with a calculation of overnights for Mr. Metelsky to reflect every weekend, every other week in the summer, and then shared holidays. I don't have that number off the top of my head, but that will get put into the new child support recommendation. Part of the court, do you think there's anything else we need to address on this matter?
Yes, Your Honor. When should the obligation cease to the current payee of support, Bar Metelsky?
Well, given that this is a stipulation of the parties, it should cease. The children are still with the grandparents right now, is that correct?
Correct.
Okay. Then we should use today's date as the new effective date.
Thank you, Your Honor.
All right. Ms. Brown, do you have any questions?
No, Your Honor.
Mr. Metelsky, do you have any questions?
No, Your Honor.
All right. Thank you both for appearing. It does conclude this matter.
Thank you.
And it looks like the parties are present. Ma'am, can you hear me okay?
Yes.
All right. And Mr. Rexick, if you could please unmute and let me know if you can hear me okay.
Yeah, I can hear you. Can you hear me?
I can. Is your video functioning, sir?
Honestly, I'm not sure what's going on with it.
Okay.
I don't
we're here
know.
today for that's okay. We're here today on a status conference. Ms. Mexick, do the two of you have any agreements at this time?
Yes, we do.
Okay. And what is that agreement?
We would like it if I took primary or sole custody, like legal and physical, and then if we could do alternating weekends during the school time and alternating weeks during the summer, and shared holidays and breaks. And then we also would like if we could request, since he does take them in the morning while I work, or during the school day, if the school isn't in session, he does take them, if we could set the child support at $400 a month.
So been a child support recommendation in this matter?
No, Your Honor.
And have you you seen a child support recommendation, or do you have any idea what the child support formula would indicate as a child support amount?
No, I don't.
And do you feel this agreement is in the best interest of the children?
Yes.
So ma'am, you're asking this court to enter a stipulated order that would give the parties joint legal custody, you the primary physical custody, with parenting time for dad to be every other weekend during the school year, every other week during the summer, and the parties would share holidays. Is that correct?
Yes, I think I asked for primary or sole legal too, though.
Oh, you're having the sole legal? Okay. So you guys have agreed to sole legal and sole physical for you?
Yes.
Okay. Is there a specific time that you would be exchanging the children on weekends?
So he works until like 11 on Friday nights, so it would have to be on Saturday to Monday.
Okay. Is there a specific time that you guys have agreed to make those exchanges on those dates?
No, we haven't. But I guess we could do, because I work at 7:30, do 7:30 to 7:30. 7:30 on Saturday to 7:30 on Monday.
And then in the summer, is there a date that you would make your changes for the every other week?
Keep it from Saturday to Saturday.
Okay. And as far as the exchanges, who's picking up, who's dropping off, or is that just something you guys will do as you agree?
Do as we agree.
And do you think this is in the best interest of the children?
Yes.
Thank you. All right, sir, if you could please unmute.
Yeah, sorry, I'm not sure why this keeps muting itself.
All right, thank you. So, sir, Ms. Mexic has put forth an agreement that she says the two of you have. Is it true that you're agreeing that she would have the sole legal and sole physical custody?
Yes, sir, that is true.
All right. And then your parenting time would be every other weekend during the school year and every other week during the summer, and you would share holiday parenting time. Is that correct?
Yes, sir, that is true.
Okay. And you're in agreement that for the school year, your weekends would be Saturday at 7:30 to Monday at 7:30, and then in the summer, the weeks would alternate on Saturday. Is that correct?
Yes, that's correct.
And do you feel this is in the best interest of the children?
Yes, I do.
She had mentioned that the two of you had discussed a specific child support figure. Is that correct?
Yeah.
And that is how much, sir?
That was $400 a month.
Okay, so the court will indicate that the parties have a stipulated agreement to sole legal and sole physical custody with the plaintiff, that defendant's parenting time would be every other weekend during the school year and a week on, week off in the summer, and the parties would share holidays. As to support, I think we need to have at least a recommendation prepared so the parties can see what that figure is before we can deviate from that. So what I would do is have the front of the court prepare a recommended support order. The parties then can object to that if they want to deviate to the $400. So what that means for the parties is there will be a support recommendation prepared. If you do not agree with that amount, meaning you don't agree to what's in that amount and you want to change it to the 400, you would have to file an objection, and then we would hear the reasons why the deviation is appropriate at that time. Do you have any questions, sir?
No, sir.
All right. And Ms. Maxey, do you have any questions?
No, sir.
All right. Front of the court, anything that you need?
No, thank you, Your Honor.
All right. Thank you both for appearing, and that does conclude. Mr. Goddard, are you able to hear me okay?
Yes, it's a little low, but yes.
All right. And Ms. Fowler, can you hear me okay?
Yes.
All right, we're here today. It appears on a couple matters. There was a ex parte motion filed by Mr. Goddard, which was denied by the judge, and then as well as Ms. Fowler has a motion regarding custody that she filed. Is that correct, Ms. Fowler?
Yes.
Okay. Ms. Fowler, anything that you would like to say at this time regarding the current status of this matter?
No.
All right. What is it that you are requesting, ma'am?
I am requesting full custody at this time.
All right. And is it accurate that there's another proceeding at this time regarding the minor child in the probate court?
I believe so. Right now, there is a no contact for her and Mr. Goddard.
All right, and that's through the probate court, correct?
Yes.
Okay. Mr. Goddard, is that correct?
Yes.
Okay. But this time, that court's order controls. Anything that this court does or doesn't do anything that this court does not impact what the other court has done. That court has entered a no contact order. So at this time, there is to be no contact. I think Mr. Goddard, you filed an ex parte motion regarding being denied parenting time. Is that correct?
Yes, Your Honor.
Okay. And Ms. Fowler, is the reason that you withheld that parenting time because of this new criminal matter?
Yes, Your Honor.
Okay. And I think we might even have is there a show cause scheduled against Ms. Fowler?
November 1st.
All right. And that's related to this, correct?
Correct.
Okay. So ma'am, as to withholding parenting time from Mr. Goddard, why is it that you did that?
Because of the case he has against him for a CSC against a minor.
So prior to the probate court issuing the no contact order, you were made aware of the allegations and then you chose not to allow parenting time. Is that correct?
Correct.
Okay. So based on that, I would dismiss the show cause against Ms. Fowler, and that court date on November 1st could be canceled. She had just cause to withhold that time, which is certainly made clearer by the other court's order of no contact. That order was not in place yet, but given the allegations and the concerns, it was certainly not inappropriate to withhold the parenting time at that time to see what was going to happen next. So that show cause would be dismissed and the parties would not need to appear on the November 1st date. Also, obviously, given that matter, the court would deny any motion by Mr. Goddard at this time to restart parenting time or to award any parenting time, any time for missed parenting time based on the current status of this matter. And given the current situation, the court would also temporarily grant Ms. Goddard the sole legal and sole physical custody pending the resolution of the criminal matter as well as the probate court matter.
Sorry, sir. Ms. Fowler?
Pardon, ma'am? Yes, Ms. Fowler.
Sorry.
Correct. So yeah, you would have the temporary legal and physical custody at this time pending the resolution of those two other matters.
Okay.
Mr. Goddard, do you have any questions, sir?
After them two matters are over, Your Honor, it goes back to the way it was 50-50.
After those two matters are resolved, you would need to file a motion indicating that those matters have been resolved and that we need to readdress parenting time.
Okay, thank you.
It's not automatic, but you would obviously have the right then to seek a change.
Okay, thank you.
All right. Any questions, Ms. Fowler?
No, sir.
All right. Thank you both for appearing. That does conclude the matter, and you may sign off. All right. We're here today regarding plaintiff's objection to the child support, as well as a motion regarding parenting time. Is that correct, Ms. Strachey?
Yes, Your Honor.
All right. So let's address the child support first. Would you please raise your right hand? Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, thank you. Would you like to say, ma'am, in support of your objection to the child support recommendation?
Well, I supplied 5 years of tax returns to show that there's possibly some hidden income there.
All right, anything more you want to say regarding that?
No, Your Honor, that's it. Other than the fact that I can't foresee Doug, as he's already stated on the record in our previous hearing, that he is anticipating taking over his father's company. And I don't see how he would be given a pay decrease for going back to the same position.
In front of the court, when you were calculating Mr. Brown's income, what was used for that?
Pay stubs that he submitted.
All right, his most recent pay stubs?
Yes,
And that was for then 2023?
correct.
Did you see the documents provided by Ms. Ratke?
What was that?
Did you see the documents that were provided by Ms. Ratke?
Yes,
All right. And in those years, does it appear that his income was higher in those years than it is currently?
I didn't further into it. I was waiting for what the court would request.
Do you know what his income was calculated at for this current support recommendation?
Yes. $18 an hour by 40 hours a week.
Your Honor, he makes, or he made $26 an hour.
Okay. And was that with the same company, ma'am?
It's for his father. He's worked for his father for decades.
All right, Mr. Brown, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, sir. So as to your current income, are you making less now than you had made in prior years?
Yeah, I'm making a lot less. We moved to Michigan. The company just kind of started going downhill since I wasn't there, and COVID happened, and yeah, we're not making the money that we used to. So that's what I'm getting paid now. I have all my pay slips. We have a payroll company. I mean, yeah, I can prove everything.
What is your current hourly rate?
$18 an hour, sir.
All right. And is that what your hourly, how long has your hourly rate been $18 an hour?
Since I came back to California, sir.
All right. I'm not sure when you moved back to California. So how long has your
February,
Pardon?
Your Honor. February, Your Honor.
All right. So February 23, it went to 18. What was it before then?
I believe it was around 25, 26. Actually, 23.50.
And what was the reason, if you know, for the $5 an hour plus reduction in your wage?
Like I said, the company is just not doing what it used to do. We lost a bunch of employees, and yeah, we don't have the workload that we used to.
And are you an employee of the company, or are you a co-owner or partner? Pardon?
Employee.
Okay. Are there other employees besides yourself?
Yeah. There's two.
Did they all? Okay. Did those employees also have the same reduction in their hourly rate?
They weren't making what I made, but I'm pretty sure no one's making any more. But they definitely have reduction in hours.
And you're doing the same job now that you did when you lived in California?
Yes, sir.
And is it your testimony that there is no other compensation that you are receiving from your employer than what you reported on your than what is reported on your pay stubs?
Absolutely not. My employer is actually here if you would like to speak to him.
Not at this moment.
Okay.
Did you provide your 2022 tax returns to the court, sir?
I don't know if I did.
All right, so it's just pay stubs from this year?
Yeah.
And what is it that what is your job title, sir?
I am an orthopedic technician.
Ms. Ratke, is there anything else you want to say regarding this matter?
Yes, Your Honor. The morals that lie in this family are few. You know, I do not believe whatsoever that he got a pay cut. When we were together, there were quite a few instances where they would be floating money. If Doug's dad needed extra money, Doug would get an extra $250 bonus on his paychecks, in which he would give cash to his father. So there was a lot of very sneaky financial stuff going on. And I don't believe that he got a pay cut at all.
Friend of the court, probably didn't do it because probably wasn't needed, but by any chance, did you look at, based on what his job is, what the average pay is for that job?
Yes, Your Honor. The base salary is $15 to 20, and then the top end is $26 an hour.
And sir, how long have you been doing this job?
18 plus years.
Okay.
Your Honor, may I make a statement?
Yes.
I would like to point out the fact that he was unemployed for a year and a half, from August. Oh, geez. So a year and a half previous to this February. And he did not want to go to that job because of health reasons. There's something about the plastic particles in the swamp cooler that were getting into his lungs. So I find it, I mean, that's just another provable lie. Because if it was truly for health conditions, he would not have gone back to that job. He exploited me in every possible way.
Sir, given your increase in your hourly wage, have you looked at any other employment with a different company that would pay you what you were previously making?
No, Your Honor.
And do you have any intent for that?
No, Your Honor. My intent is to stay with the family business and try to build it back to what it was.
All right. Anything else you'd like to say, sir?
Yeah, I mean, the essence that she's just bad-mouthing my family and making things up is just ridiculous. I mean, I have all my pay stubs. I have, proof of everything I make. And yeah, this is just hearsay.
All right. Well, some of it is speculation, but it is also established that you have taken a significant pay cut. One thing the court can look at is what is a person voluntarily unemployed or voluntarily not exercising their ability to earn the potential income. So you were making sufficiently more, you're now making less, and you're not looking to make up that gap. And it sounds like based on your experience, your pay level should certainly be higher than $18. That range was 15 to 26, is that correct?
That's correct.
All right. So, sir, you indicated that before your pay got lowered, you were making $23.50. Is that correct?
Yes, Your Honor.
Did you ever make more than $23.50?
No.
And how many hours are you working, sir?
40.
Okay. All right. So based on the testimony and the objection, the court is considering the potential income for Mr. Brown. So, Mr. Brown, your pay decreased when you moved from California to Michigan. Is that what you're saying?
No, I wasn't working when I moved to Michigan, and then I came back to Michigan, or I'm sorry, I came back to California, and then I took a pay cut because the business just wasn't doing what it used to.
Okay, you're in California. Sorry. All right.
Yeah, we lost a bunch of employees, and then the COVID happened, and yeah, it's just the shop's not doing what it used to.
All right. So you're still in California. You're not working. This business is not operated in Michigan, correct?
Correct, Your Honor.
Okay. All right. So based on the testimony and the years of experience for Mr. Brown, he clearly has the ability to earn more potential income. He's taken a significant pay cut and not looked for a new position that can pay him in that pay range given his experience. So I will grant the objection and impute his income to $23.50 an hour. So a new support recommendation should be prepared. The parties again will have the opportunity to object to that recommendation.
I'm sorry, what was that, Your Honor?
You will have the opportunity to object to my recommendation, but my recommendation is that your income be imputed at $23.50 an hour. That is, it appears that is income you could certainly earn. You've not sought to replace that decreased hourly rate, and given your experience, that seems as that's not even at the top end of what really it could be imputed to. So we will impute it to what it was before as $23.50. You do have the right to object to that.
I object, Your Honor.
Information will be sent to you, and a copy of the recommendation will be sent to you, and in that packet of paperwork, it'll tell you what you need to do to file an objection and schedule the matter before the judge.
How does this work without you guys even receiving any paperwork or looking into this?
All right, sir, I made my decision based on the testimony that was provided by the parties as well as in front of the court as far as the range of income for that position. All right, we'll move on to the motion regarding custody. Ms. Racky, as far as your motion regarding custody, what are you seeking to change or do?
Your Honor, I'm seeking to eliminate the Zoom calls and to also request if Doug ever does make the attempt to come out to Michigan, that his visits be supervised, which is, I did request that in the first one, but I was so nervous. I missed it when you get your order.
All right, what is the current schedule for Zoom calls?
Mondays and Thursdays at 8 p.m. Eastern.
All right, and are you saying he's, for the record, what is the problem with the Zoom calls?
He's using it, not every time, but there's been a few times that he's used it to continue to verbally abuse me.
Is he using the Zoom calls to verbally abuse you?
Yes.
How is he doing that?
Well, I've documented everything, and I also have screen captured everything to show the length. River really doesn't understand. He doesn't recognize him for who he is. And it's becoming intrusive to my schedule because I'm a single mom of 3 and I work full time. So on September 7th, they were having the Zoom call and they had already finished, waving bye to each other. And I removed the camera and I put my thumb over the camera, and to which Doug says in the background, "I fucking hate that bitch with all my heart," just because I was about to end the Zoom when they had already said their goodbyes. Monday, this past Monday, was another good example. Monday was also the final tax day for those who chose to file extensions. And I had a lot going on that day. At 8:15, I received a phone call and I immediately answered the phone. And I said, "Oh my God, Doug, sorry, I'm so sorry." And he immediately starts yelling at me. And so I tried my best to put a stop to that. And I asked him to not fucking talk to me that way anymore. I apologize for my language, but that's how I said it. And I said, "Did you still want to do the Zoom call?" I had honestly forgot. I had just finished up my taxes. I had my phone on Do Not Disturb. I was trying to turn the heater on for the first time in the season. I had a lot going on. I genuinely spaced it. And he proceeded to yell at me even after I apologized. And I don't feel like I need to be put through that anymore. And the fact that River doesn't even acknowledge him at all. I mean, they're completely pointless in my opinion and do nothing to serve River's well-being.
All right.
And I also, Your Honor, I do want to add that my PPO was unfairly terminated in June. And
hold on. So what we're going to do is set this matter for an evidentiary hearing. We're not going to have time, given the number of cases the court also has before or after your case. So As far as the motion regarding parenting time, we'll set that for a evidentiary hearing. We will set that for December 13th at 11 a.m. That will be by Zoom. And then we will address this issue with the parenting time issues raised by Ms. Ratke at that time. Then I'll give both parties a chance to present testimony.
Do I continue Zoom calls until then?
It is part of the court order, yes, ma'am.
Okay.
Mr. Brown, obviously your behavior needs to be appropriate. If there's certainly other issues that are addressed that occurred after today's date, that's not going to help you whatsoever. The Zoom calls are meant for an opportunity for you to speak and see the child. It's not an opportunity for you to interact with Ms. Ratke. Do we need to adjust the time or something like that to make these more set? Because what seems to be a problem is back and forth regarding, hey, what time are we doing this? Does 5 o'clock work? Or those type of things. So what I would like to see is a way to make it so the two of you have the least amount of interaction as possible. So if we had a specific time that was always going to work, we could do that. Is the issue, Ms. Ratke, that the time that is scheduled is not always appropriate and the two of you need to switch it?
Well, Your Honor, River goes to bed between 8:30 and 9:30. So 8 o'clock really is ideal for me, being that it's kind of at the end of the night and we're all winding down.
All right. Mr. Brown, what's wrong with 8 o'clock calls?
There's nothing wrong with it.
All right. All right. So it's pretty simple. The calls are scheduled for that specific time. That's when they should be happening. There doesn't need to be probably pretext beforehand to say, can it happen? Ms. Ratke will have the child available for those calls at that time. You don't need to have interaction back and forth prior. Just make those calls at the appropriate time, which I think is 5. Well, no, it's 8 o'clock Eastern, 5 o'clock for Mr. Brown in California. So, Mr. Brown, when you're making those Zoom calls, there's no need to reach out to Ms. Ratke. Make your call at the appropriate time. And your interaction should be limited to your interactions with the child. When the child is done with the Zoom call, that is the end of it. And you certainly should not be making any comments regarding Ms. Ratke, okay?
Yes, Your Honor.
All right. We'll see you both back here on December 13th at 11 a.m. Thank you.
Thank you, Your Honor.
Ms. Doyle, you do not have an attorney at this time?
No, I do not.
And Mr. Higdon, nor do you. Is that correct?
No, Your Honor.
All right. So, Ms. Doyle, this is your motion regarding parenting time. Is that correct?
Yes.
Okay. And just briefly, what are you seeking to change?
Well, we've also had another change of circumstances. The supervisor is now resigning. Her last weekend was supposed to be last weekend, but because of a emergency situation, it's been moved to this weekend. So we don't even have a supervisor anymore. But what I'm requesting is that drug tests be done prior to visitation being done, so that way the safety of the children is being taken. So that way he's not using prior to a visit or during.
Has there been an incident where he was under the influence during a visitation?
I'm not there. I wouldn't know.
So there's been no reports of that?
No, I have no clue. I just know that he's always used, as far as I know. This has been a concern that's been ongoing, and there's never been any proof to prove that he has an issue with any kind of substances. And now that it's been through the court process and everything, there is actual proof that he is using.
Actual proof that he's using in the presence of the children, or just that he has used at some point in time?
That he does use. I know he hasn't been able to pass a drug test.
Yes, I have, Your Honor.
All right. Well, again, it sounds like there's been no proof of some issue of Mr. Higdon being under the influence during parenting time. We have a supervisor that could always testify whether or not that is a concern or not, but there's been nothing indicated in the filing that the supervisor has indicated there's been a concern with Mr. Higdon's use of substances during his parenting time. So the issue of the supervisor sounds like it's brand new. Is that correct, Mr. Higdon?
Yes, Your Honor.
And
She notified us a couple of weeks ago that she was going to be quitting. So,
Who was the last supervisor?
Valerie.
The Silva Lampic.
Yeah.
What was her relation to the parties?
She was a neutral party, a friend of both of ours, and yeah.
It's not so
Have the
much
two of you
mutual, but
The two of you discussed a new supervisor or not?
I've suggested several. That was quite a while ago. Every single one of them has been turned down for some excuse or another. I've even suggested a pastor at a church that neither one of us attends, neither one of us has any relation to, know anything. He's just a pastor at a church. And that was turned away as well.
Your Honor, I contacted that pastor and it wouldn't have even been that pastor. He said they could possibly get somebody to do it, but I would probably have to pay them and everything else. I've tried this already. I contacted him.
So two of you are not
won't
able
agree
to.
anyone I suggest either. And this has been going on for a year and a half, Your Honor.
So the supervisor's done when? Already or in the future?
As of this Saturday.
What is the current parenting time that you receive, Mr. Higgin? How often?
I get the kids every Saturday from 4 hours.
Okay. So, Mr. Higgin, who do you propose? Who do you propose as a supervisor?
Well, I tried also trying to get my mom to do it even, and she was willing to do it, but Miss Doyle decided to deny that as well.
It needs to be mutual, and it needs to be neutral.
Well, I mean, here's the problem. All right, so he's got one more visit left, and then we're going to be run out of time to have. We won't have a supervisor, so there needs to be an immediate addressing of that issue, even if it's just somebody temporarily until we have potentially a hearing on the issue to determine who it should be. We do not have time at this moment to do a full hearing on who the supervisor should be. The two of you are adults who should be able to co-parent and reach some type of agreement on who's going to do supervision. But I think the two of you have a history of just choosing not to cooperate with each other no matter what, to be the one that wins the situation. So that's probably why the two of you have not been able to come to an agreement, because you just prefer to not agree. So I think we need to, at least if you can't agree to somebody, we need to agree to a temporary supervisor to guarantee that these visits are continuing to happen. And then we can have a full hearing if needed on a supervisor. So, Ms. Doyle, who do you propose, or do you have more than one person you can propose to at least do supervision at this time until a final supervisor is picked?
I'd still be okay with doing, I think it was Steve Datema at the Friendship Church.
Do we know if he's even available?
I don't. I haven't been able to get a hold of him recently. It's been quite a while since I contacted him, so he might not even be able to have the schedule work with him. The other thing would be to either do it at DHS or to do it in Traverse City at the specialized facility.
Mr. Higgin, what are your thoughts on a supervisor?
Honestly, I wouldn't mind even doing it at DHS, but I can't. I don't have a license, so I wouldn't be able to go all the way to Traverse City.
They won't do that unless it's part of a neglect and abuse case, so that's not an option.
Yeah. Honestly,
You suggested your mother, is that?
I apologize. Yeah, I said my mother. Yeah. I mean, it's somebody to watch me, is it not? I mean, I don't know, Your Honor.
It needs to be a neutral party, and that was what Mertz had ordered, is it has to be a neutral party.
Well, Mertz
that
also
has no
ordered
connection.
Mertz also ordered that I have a second day, Sunday, to be able to get makeup time, and that hasn't happened either. So, because you won't allow it, you won't allow me to have 2 days with the children. So,
Specialist has recommended not to do 2 days in a row. We
Yeah,
could do a
specialist,
Sunday if
but I'm not-
Saturday didn't work.
All right, both of
Never
you.
even said
All right,
anything.
Mr. Higdon and Ms. Doyle, we don't
Sorry,
need you both
Your
going back and forth and just arguing, okay? We're here to try and resolve an issue related to parenting time, related to the kids having time with their father, not for the two of you to bicker back and forth like you always do. All right, I'm reviewing Judge Mertz's recent orders in this matter. That ordered parenting time shall only be exercised between defendant, the children, and the supervisor, and appointed Valerie Zampich as the supervisor. I don't see any specific terminology about quote unquote a neutral supervisor.
It might have been an order prior to that one, but he did state it needed to be a neutral party.
Ms. Doyle, is it correct that he has parenting time every Saturday?
Yeah, from noon to 4.
Okay.
It was 1 to 5, but we had to adjust it to noon to 4 because of the medications.
Mr. Higdon, do you live with anybody?
Yes, Jake Triban.
And where have you been doing your visitations at?
At Burger King for 4 hours in Gaylord. I honestly was getting ready to file for more time because it's only been 4 hours and this has been going on for almost 2 years, Your Honor.
Is it your intent at this time to continue to do the parenting time at Burger King?
That's the place that we agreed upon, but I would rather do it at my home.
Well, if you're doing it at Burger King, I'm a lot more comfortable than considering a different supervisor because it's a much different situation, and I don't think there's as much of a concern as Ms. Doyle would have as if it's at a residence.
Okay.
So, Ms. Doyle, if he's just exercising it at Burger King, do you have any good arguments to me as to why his mother can't supervise that?
She's not neutral. It's just not a good mixture. My kids and I were removed, or my son and I were removed from her home while I was pregnant with my daughter because she put her hands on me. And she only sees the kids under my supervision.
What does that mean?
That means I don't even trust her to be alone with the kids.
Okay.
No sense. She has never harmed the children in any way, but okay.
Mr. Higdon, when was the last time your mother saw the children?
Recently, honestly, she was with Amanda. I believe at a
couple weeks ago.
Okay. All right, so based on the testimony of the parties, Ms. Doyle has filed a motion regarding parenting time, requesting some type of drug testing for Mr. Higdon due to a recent criminal matter. And also now has been raised that the supervisor is no longer available, so there is proper cause and change of circumstances to review the prior orders. As to the request for drug screens, that request is denied. There's been no evidence presented to the court that during Mr. Higdon's visitations, which are supervised, that there has been any issues or concerns regarding him being under the influence of substances. So that request is denied. As to the issue of the supervisor, I'll indicate that it's the court's recommendation that Mr. Higdon's mother be allowed to be the supervisor, provided that the visit is occurring in a public place.
Your Honor, my brother was the supervisor at one point, and it was taken off because he was family.
Well, I mean, that's my current recommendation. It is only a recommendation. The parties do have the right to object and have the matter heard before Judge Mertz.
Okay.
All right. Any questions, Mr. Higdon?
No, Your Honor. The only other question, actually, yes. Does it have to be at Burger King? Like, the kids kind of are sick of going to Burger King all the time. Can we go to like a bowling alley or something that's still public? Or the
Right,
library?
My recommendation was that it has to, as long as it's your mother and Ms. Doyle has these concerns, then it does have to be in a public setting.
Yeah, that's what I was asking, Your Honor. Could it be like at a bowling alley instead, or that, or it doesn't have to be?
Alley, it can be at the sportsplex. Yes, it can be in a public setting. It can
Okay.
only be in a public setting.
All right.
All right. Thank you. Thank you, Mr. Hickman and Ms. Doyle. You're free to sign off.
Thank you, Your Honor.
What is the status of this?
Friend of the court motion to administratively close the 4D case and remove the arrears from the Michigan Child Support Enforcement System, but also preserving those arrears. The reason for this is the friend of the court has obtained information from the Social Security Administration that the defendant is the recipient of SSI and that he currently does not have an ability to earn income. And since he's receiving SSI and it's a means tested income, we cannot collect that or use it for the calculation of child support.
Okay. And Ms. Dreffs, what would you like to
Yes.
say on this matter?
Well, okay, so my son will be 15 in January. I've never received anything from Mr. Gage, like at all. And I just feel like, I don't know, like at this point, I have no idea. I just feel like if he's getting something, then my son should get something. I'm not even concerned about me because, like I said, I've done it for 14 years by myself. But I know, like, my mom and dad used to do like adoption and stuff, and my younger siblings that they adopted would get something from their SSI. So I'm here on behalf of my son to, if he's able to get something, I would kind of like them to see he's 15. He's never had any time with this man, like nothing. I feel like my son owes something.
If there is something he's entitled through through SSI, through Social Security, that would be dealt with through them, not through the court. I can't order the Social Security Administration to make payments.
Right, but what I say
there
is I don't have any contact with Mr. Gage to get any of that information. He doesn't call. I mean, it's like essentially, for lack of better terms, sperm donor.
And you as a parent of a child with another parent on SSI, I don't know if you've tried to reach out to the Social Security Administration to see if you advise them that, hey, I've got this child and their father is receiving disability benefits. I'd like to apply for any benefits that child is entitled to.
I have not tried that. I didn't know I could.
Okay. And I'm not sure. Calls to Social Security is not always the easiest thing in the world, but that's what I would recommend, is to reach out to them and tell them of that situation. If Mr. Gage did not advise them that he has a potentially eligible child, perhaps you can provide that information to them. Our hands are tied as far as what we do, because the court cannot intercept any SSI money from an individual.
Right, and I wasn't sure what exactly the grounds of how all this worked anyways. But like when I got the paperwork, I was like, okay, so 14 years of nothing from this man, my son should get something. Like, so.
Right, and that may be an avenue for Social Security that can be pursued, but the court here cannot intercept that SSI money.
Okay.
So I would grant then the friend of the court motion to administratively close this case.
Thank you, Your Honor. Just the friend of the court indicate that a review will be conducted in 2026 to determine if there's still no ability.
All right, thank you. All right, Ms. Dreffs, thank you for appearing. It does conclude the matter, and you may sign off. Karsten, can you hear me okay?
Thank you. Yes, I can hear you.
All right, and Mr. Campbell, if you could unmute, let me know if you can hear me okay.
Yes, I can hear you just fine, sir.
All right, thank you. All right, this is a new custody matter that was filed before the friend of the court regarding the issues of custody, parenting time, and support. Ms. Carson, do the parties have any agreements on those issues?
We talked about it a little bit, and we've come to a little bit of an agreement. The paperwork that I submitted to the court was our first initial agreement until he decided he was going to pack up all the kids and leave the state without my permission. So I haven't seen my kids in almost a month, and circumstances are much different than what they were when I first submitted the paperwork. So I don't even really know what the best option would be at this point. I was hoping we could all talk and then resolve something while we're here.
Well, we have an option to do with the court, one of two things. We could refer the matter to mediation, which would give the two of you an opportunity to meet with the mediator and have discussions and see if you can resolve the issues, or we can set the matter for a court hearing where both of you present your arguments exhibits, and witnesses, and then the court makes a decision. Would you like to try mediation, or would you like to proceed to a court hearing?
I think mediation would be okay. I don't think it
All
would
right.
break out into an argument.
Sir, are you willing to participate in mediation?
Yes, Your Honor.
Okay. So then what we'll do is we'll refer this matter to community mediation. They will reach out to you to set a time for that to happen. If you reach an agreement, then the court can adopt that agreement. If you don't reach an agreement, then what we would do is set the matter for an evidentiary hearing. So we'll set this matter for a status conference in about 60 to 90 days to allow for that mediation to happen. Again, we'll refer the matter to mediation, so they will reach out to both of you. Make sure you cooperate with that process. Any questions, Ms. Carson?
60 to 90 days until we get the mediation.
No, your mediation should be before that. What I said is we'll set a status conference with the court after that mediation. Mediation will probably be in touch with you pretty promptly. You should be able to have your mediation, I would say, within a 30 to 60 day range, but hopefully closer to that 30.
Okay.
Are you okay with that, ma'am, or do you want to proceed a different way? We could have a court. Well, the soonest we could have a court hearing is December 20th. Would you rather have a hearing on December 20th, an evidentiary hearing, or would you rather try the mediation?
We can try the mediation. It's okay. I just miss my kids.
Well, Mr. Campbell, is there a reason that you don't have some sort of temporary agreement on where the kids are going?
Right now, I have moved back to Washington State with the children. My grandfather, their great grandfather, is not doing very good in health.
All right.
Dustin's family gave him $4,000 to pack up nothing and take my kids and leave the state while I was working. And I didn't want to cause an issue like we've had before, so I wasn't going to argue with him and cause another domestic violence situation like what we had years ago or anything like that. So I was hoping we could figure it out with the court. And
so, sir, are you planning to continue to reside in Washington?
Yes, Your Honor.
All right. Well, that's going to obviously create some issues regarding parenting time. I think it's more appropriate to get this matter on a evidentiary hearing docket than given those circumstances, as well as concerns regarding past domestic violence. Sometimes mediation is not appropriate in those circumstances when the parties do not have counsel. So at an evidentiary hearing, the court considers the best interest factors of the children. One of those factors is, does a parent promote a strong relationship between the children and the other parent? So things like withholding or not allowing parenting time are certainly things that are considered as one of the best interest factors. So given the circumstances, we're going to give you the quickest date we can give you, which is we're going to do an evidentiary hearing on December 20th at 11 a.m. by Zoom. We'll send you that notice. We are not going to refer the matter to mediation. Obviously, the parties themselves are free to talk if they wish to talk to try and make an agreement on parenting time. We'll have an evidentiary hearing then on December 20th at 11 a.m. Any questions, sir?
No. Is the meeting gonna be the same way through Zoom?
Yes.
Well,
Yep.
how will I receive that number? Do I need to call the court and get the number, or?
This is the exact same number you use now. We are going to send you a notice.
Okay.
Let me make sure we have can you give the court your correct mailing address?
2, apartment G 104.
All right. Did you get all that?
Yes.
Okay. And ma'am, what is your mailing address? Okay. All right. Thank you both for appearing. We'll see you back here then for the evidentiary hearing on December 20th. Thank you.